This story was originally published on May 6. It has been updated to reflect the Supreme Court's final decision. The Supreme Court's Friday ruling to overturn Roe v. Wade is almost certain to spark a wave of new state legislation taking aim at abortion rights, and to reinforce existing laws that prohibit and, in some cases, criminalize the procedure. Among the wide-ranging potential implications of the decision are concerns about the potential use of personal data to punish people who look for information about or access to abortion services online in some of the most restrictive states. Digital rights experts warn that people's search histories, location data, messages and other digital information could be used by law enforcement agencies investigating or prosecuting abortion-related cases. On Friday, the Supreme Court struck down Roe v. Wade, the 50-year-old ruling that guaranteed a person's constitutional right to terminate a pregnancy before viability, usually around 24 weeks. A draft of the opinion leaked in May. Overturning the landmark 1973 court ruling is expected to transform the landscape of reproductive health in America, leaving abortion policy up to individual states and potentially paving the way for more than 20 states to pass new laws restricting abortions. Even before the ruling, concerns about the digital privacy implications of abortion restrictions had started to arise amid a movement by Republican-controlled states, including Georgia, Texas, Mississippi and Oklahoma, in recent years to pass laws severely curtailing access to the service. America is a much different place today than in the pre-Roe era. Because of the pervasiveness of the Internet and mobile technology, people today share vast troves of data about themselves, whether they realize it or not, opening the door to significant surveillance. The possibility of a complex patchwork of state laws following the rolling back of Roe v. Wade raises a host of new questions about the everyday technology Americans use to make health decisions and how it might be used to enforce those laws, and could create confusion about what online behavior is permitted or not. America is a much different place today than in the pre-Roe era. Because of the pervasiveness of the Internet and mobile technology, people today share vast troves of data about themselves, whether they realize it or not, opening the door to significant surveillance. The possibility of a complex patchwork of state laws following the rolling back of Roe v. Wade raises a host of new questions about the everyday technology Americans use to make health decisions and how it might be used to enforce those laws, and could create confusion about what online behavior is permitted or not. For example, in states that make it a crime to help an abortion seeker, data from women's period tracking or pregnancy apps could end up being subpoenaed as evidence against the person who helped them, said Danielle Citron, a law professor at the University of Virginia and author of the forthcoming book, The Fight for Privacy. Let's say you got your period, stopped period and then got your period again in a short time, Citron said. It's potential evidence of your own criminality, or your doctor's criminality. Groups promoting digital rights and reproductive freedoms are now warning people in states that criminalize providing access to abortions to safeguard their digital footprints when seeking abortion information and resources online and sharing tips for how to do. We are living in a much more surveilled culture than we were in 1972 and prior. So in a future where abortion rights are limited or there's not a federal right, people will be at risk for exercising their bodily autonomy, said Elizabeth Smith, Director for State Policy and Advocacy at the Center for Reproductive Rights. The consequences of those decisions are likely to fall hardest on Black, brown, Indigenous people of color.